Good morning to you all.
Good morning, Mr. Commissioner, members.
I think
Mr.
today
Commissioner,
is the 21st.
We are ready to proceed on the 21st of May. We plan to have 3 witnesses today. The first one is ready to take the oath, Mr. Benedict Mongalu, and my colleague, Advocate Gue, will lead the witness. Thank you, Mr. Commissioner.
You are familiar with proceedings here?
I am.
And you don't have any objections to taking the oath? Nothing has happened in between your coming here the first time and now?
No objections.
Right. But you have to take the oath again. Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You can sit down.
Thank you.
Thanks, Joe. Yes, Ms. Gue.
Thank you, Commissioner. Good morning, Commissioner and members. Mr. Benedict Mongalo is going to be testifying on the SA home loans transaction, and I'm going to start leading him now. Am I correct that you have prepared a statement for this commission?
That is correct.
Am I correct that you were not coerced to say anything in the statement that isn't true?
That is correct.
Am I correct?
I suppose and I'm thinking back during my days on the bench, whether that's a leading question or not. Carry on.
Thank you, Commissioner. I believe at the beginning we are allowed to lead him just to get him to start with his statement. And you have not been coerced to make the statement?
That is correct. I haven't been coerced.
All right, thank you. You can start with your statement from paragraph 1.
I am an adult male currently employed by the Public Investment Corporation SOC Limited, PIC, as a fund principal in the Impact Investing Division. I've been employed by the PIC since September 2012 and have held various job titles and responsibilities in risk, private equity, and impact investing divisions. My qualifications include a Bachelor of Commerce accounting degree, a financial services diploma in credit risk, and a Master of Business Administration MBA degree. I have been requested by Mr. Tina Sriede, a staff member of the Judicial Commission of Inquiry, to provide a statement providing a detailed account of my knowledge of activities relating to the issue of transaction fees in the SA home loans transaction. The purpose of this statement is therefore to detail my knowledge on the issue of fees and activities that took place in the SA home loans transaction. In providing the facts contained in this statement, I have relied on certain documents that were prepared for some submission to the relevant committees in relation to the SA home loans transaction, email correspondence between myself and the relevant parties, and also documents submitted by the funding applicants and other related parties. On the background, in providing a detailed account of the issue of fees, it is worth providing a background on the 2 main transactions done between PIC and SA home loans, which are detailed below. The business relationship between PIC and SA home loans started in 2013 when PIC, on behalf of the Government Employees Pension Fund and a broad-based Black Economic Consortium, Bolacha Hloho Consortium, or BHC, acquired 50% equity holding in SAHL Investment Holdings. SAHL is the ultimate parent company of SA home loans. BHC itself is a consortium led by Mr. Kulofelo Maponya and was funded by PIC to acquire their 25% equity portion in SAHL.
Right, can I just ask you there, what did the PIC pay for that 50%?
I paid around 480 million rand, Commissioner.
And how much did the funding then to Maponya was half of that? Was that provided by the PIC?
Yes, it was for the same amount. So it was the PIC's equity of about 480. I can get exactly the same. I mean, roughly it was about 480 million rand.
For the 50%?
For the 25%.
So, okay, so it was, so for the 50% it would have been double that?
Double that, yes. That's correct.
So PIC paid double, and then Maponya was 480 million for its 25%?
Yes, he was funded.
And that was a loan from the PIC?
That is correct.
And did Maponya put in any of their own finance?
Not to my knowledge. I must just say, Commissioner, that I was not involved in the transaction. So I got involved in the subsequent transactions, but to my knowledge, no, there wasn't any funding that was put.
And was that being serviced?
It is being serviced, yes.
Okay, thanks.
As part of the transaction, PIC nominated Mr. Roy Rajda and Mr. Wellington Masegesa to serve as non-executive directors of SAHL. The second transaction entailed PIC on behalf of the Government Employees Pension Fund advancing debt funding package totaling 10.5 billion rands to SA Home Loans through the ring-fenced managed insolvency remote special purpose entities. The total facilities which were for specific purposes were split as follows. One, South African Mortgage Fund, it's a ring-fenced entity, so 5 billion rand. South African Mortgage Fund 1, PT1 Limited, 4 billion rand, and the South African Housing Development Fund, a DEV Fund, 1.5 billion rand. The issue of fees only arose on the second transaction, and consequently this statement deals with the second transaction. Litigation.
Sorry. Yeah. Do you know if there's a difference between 9.1 and 9.2, those different funds?
Yes, so they were for specific purposes. 9.1, which is the 5 billion rand, was a funding line for SA Home Loans to advance funding to the government employees. The second one, which is the 4 billion rand, it was divided into two. There was 2 billion rand for them to on lend to the affordable housing segment, and then the other 2 billion rand was towards the what we call the traditional market, their normal lending business. On paragraph 11.
Sorry. And then 9.3, what was the difference there? What was it aimed at?
So 9.3, it's a development fund. This is a fund that was established for SA Home Loans to lend to the affordable housing developers, property developers.
It's a developers fund.
That is correct.
For developments?
Yes.
Lending or shares or the equity, because you can lend them, you can lend to them and then you can inject the equity also
Lending.
in those projects.
It was lending. They are all debt facilities. Yes.
Okay, like Nedbank would lend to projects.
That is correct.
Okay.
Yes. And paragraph 11, it is worth noting that the matter of fees in question is currently subject of litigation initiated by Matume Maponya Investments, Pty Limited, or MMI. The summons which were served on PIC are attached as Annexure A. Origination of the transaction. My involvement in the transaction commenced on the 29th September 2014 when I received an email from the CEO's office to work on a debt funding package for SA Home Loans. The email to myself was pursuant to the proposal received from the then Chief Financial Officer of SA Home Loans, Mr. Rob Kelson. The email correspondence is attached as Annexure B. The transaction approval process, so in line with the unlisted investment approval process, the transaction for SA Home Loans was considered by the following committees. The Portfolio Management Committee, Unlisted Investments, on the 18th of November 2014, that's PMC1. It then was considered by Portfolio Management Committee, Unlisted Investments on the 9th of April 2015, that's PMC2. and it was subsequently approved by the Investment Committee on the 14th of July 2015, with a subsequent variation that was done on the 17th of December 2015. The extract of the minutes of PMC deliberation is attached as Annexure C and C1 respectively, whilst the Investment Committee resolution and the subsequent variation of conditions presented to the committee is attached as Annexure D and D1 respectively. As indicated in the attached resolution, the Investment Committee approved the transaction subject to upfront fees of 50 basis points of the total debt commitment, so that's excluding the debt fund commitment being charged. Considering the total debt commitment of 9 billion rand, the upfront fees amounted to 45 million rand, exclusive of VAT. The amount in question was levied and capitalized onto the loan facilities on the effective date of the facilities.
So just to be clear, that 45 million is equivalent to the 0.5%?
That is correct.
Okay.
Discussion on the fees. So in executing the transaction for SA Home Loans, I've dealt and negotiated commercial terms extensively with SA Home Loan staff, in particular the CFO, or the then CFO, Mr. Rob Kelso. The proposed upfront fee, which comprised of the arrangement and underwriting fee, was a figure negotiated downwards from an initial 100 basis points. During the preparation for the PMC2 submission, there was an internal discussion about sharing the fee with BHC, or with Bulacha Hloko Consortium, which culminated in the proposal for to PMC2 that the proposed fees be shared equally with BHC. The fee sharing proposal was, however, subsequently removed. I do not have the recollection of the circumstances around the removal of this proposal in the final submission to the Investment Committee. I could, however, assume that perhaps it was due to the unavailability of the explicit mandate with BHC or indicative terms of that arrangement, if any. Accordingly, the final approval by the investment condition included a condition that all the upfront fees charged are payable to PIC in its capacity as the lender. The finance agreements for all the transactions were signed on 21st December 2015. The issue of the fees resurfaced, with MMI contending that there are fees amounting to 45 million rand payable to them, albeit there was no written mandate and or agreement.
Sorry, can I just ask you a question there?
Yes, sure.
If the agreed loan was at 0.5%, why would MMI be asking for fees of 45 million, because that would be the whole fee? Is he still assuming, or are they still assuming, that it was a 1% fee? And second of all, would it be normal, if you look at your paragraph 17, would it be usual for there to be a discussion about fees being paid to somebody where there isn't a written agreement or an understanding at the outset of who has what and what fees should be shared and so on? Why would this even come up if the PIC's documentation and arrangements were clear? Because this seems to me to be a lot of who said what. So I don't understand the 45 million if the lending agreement was at 0.5. It should, if he's claiming half, it should be 22.5 million, not 45.
Yes, Commissioner, so I deal with this matter later in my statement around who played what role, but I think the issue of the 45 million rand, as I've indicated, we negotiated a fee which was at the time 100 basis points, which would have been effectively 90 million rand. So it may well be that the claim of the 45 million rand came from the assumption that we are collecting 100 basis points. But the agreement at this stage, they were completed, and they were explicit in that it was 50 basis points. In essence, what is being claimed, it's the full amount that has been charged.
And then, well, go on.
Yes, yes. So in paragraph 19, following an internal discussion with Mr. Roy Rajda, my land manager, it was agreed that to the extent that there are services rendered to PIC by MMI, we should approach the initial sanctioning committee, being the PIC Investment Committee, to seek approval. In this regard, the view was that the fees earned on the transaction will be paid to MMI, and accordingly, PIC would merely act as a collecting agent.
I'm not sure if you can answer it or whether it's Mr. Raja who needs to answer it, but that sounds quite extraordinary, that you take no fees whatsoever, and were there actually services rendered?
So, Commissioner, again, I deal with this issue later on in the statement. I think the view that the PIC...
I don't refer to the... I've read the statement. I know what you're referring to. I'm asking you to explain it in relation to saying that you're giving up any fees in relation to MMI. Were you convinced that there were services rendered?
Well, I think if there were services rendered, it would have, I would say that it would most probably be a referral fee, but even in that case, we have not been able to prove the referral, given that this transaction, as I've indicated, was originated by the SA Home Loans team. So if we're talking about the arrangement mandate is quite clear on what the arranger needs to do to facilitate a transaction. And we have the view that it was not an arrangement mandate. Firstly, there wasn't an explicit arrangement mandate which was signed, and secondly, there wasn't a proof of rendering those services. So what we have charged instead as PIC, we have charged, participation fee, which was arrangement and underwriting fee, because we underwrote the entire tranche of the facility. And what is being claimed here, or based on the invoice that has been provided, is that these are arrangement fees. And arrangement fees in the ordinary course are paid by the borrower, because the borrower would have given the mandate to the arranger, but not the lender.
I understand that. My query is how you agree that the transaction that the fees earned will be paid to MMI and the PIC would merely act as a collecting agent. I don't know how you come to that agreement on the basis of the information that you have just reiterated.
Yeah,
because you're saying you agreed that. I just don't understand why, but maybe continue and it'll come clearer.
Okay. Paragraph 20, we prepared a memo for investment committee submission on the 26th of February 2016, and that specific memo never served at the committee as it was not recommended by the CEO.
Now that memo would have reflected paragraph 19's agreement.
That is correct, yes. To my recollection, the reasons for not recommending the submission to the committee included that the fact that the PIC did not have a mandate with MMI to render the specific services. And even if there was a mandate, it would be irregular for PIC as a lender to pay an arranger of the facilities. The view held was that if any arrangement was to be paid, then the borrower should pay it.
Sorry, at this point in time, I need to ask Commission, I beg leave to hand up the memo. I received it a bit later. And now,
what would be the next annexure, Ms. Commissioner? H? Will the next annexure be H?
It will be annexure H. Now you just explained to the Commission that this memo that was written was not recommended by the CEO. Now my question is, who had instructed you to draft the memo in the first place?
So I had a conversation with my land manager, Mr. Roy Rajda, and we were served with the invoice. And I think our view was that if there is a fee to be paid, then such fee needs to be deliberated upon by the committee, and we submitted a memo to that effect.
Was the CEO aware of this?
The CEO was given the memo, and as I've indicated, he did not recommend the submission of the memo. He actually wrote on the memo that is not recommended. I think on the last page of the memo indicate his signature there.
Thank you, you can continue.
So from paragraph 21, we have been provided with the minutes of the deliberations of the Board of Directors of SA Home Loans and the legal opinions that were considered at the time. The documents were provided to PIC by Mr. Maponya as part of the negotiation of the fee dispute raised by Mr. Maponya. Based on the information provided, my understanding is that SA Home Loans Board deliberated on the issue and resolved that there is no basis to pay MMI any fees. On or around the 29th of April 2016, following an internal discussion, I was requested to prepare a session of fee letter to be issued to SA Home Loans. The effect of that letter is that SA Home Loans would pay the fees to MMI. My understanding is that the decision was as a result of the discussion held between the PIC nominee directors and the CEO of SA Home Loans.
Who asked you to prepare that session of fees letter?
Commissioner, it was a discussion with Mr. Rajda. I then drafted the session letter as requested and asked the legal department to vet the letter. Once the letter was vetted, it was signed by the CEO and sent to SA Home Loans. The session letter is attached as Annexure E. Following the issuing of the session letter, on the 5th of May 2016, we received an email from Mr. Maponya indicating that the company secretary of SA Home Loan insists that the board of the company has to approve the session by PIC, which he considered irregular and improper, should be improper. Yeah. My understanding was they needed to approve the payment on the back of the session letter issued by PIC, given that it was effectively regarded a related party transaction. He requested that PIC get clarity on the legal standing and reasoning. The email was forwarded to Mr. Ernest Nesani, the Executive Head Legal Counsel, who indicated that the board of SA Home Loans should seek advice from his own lawyers and not PIC legal. The email correspondence is attached as Annexure F. On the 9th of May 2016, Mr. Nesani and myself had a discussion with the CEO of PIC. He indicated that there was a bilateral meeting with the representatives of Standard Bank, who are co-shareholders in SA Home Loans, and the understanding was that there is no mandate between SA Home Loans and MMI, and accordingly there was discomfort with the company paying the sought fees. In view of the discussion and the understanding that no services were rendered by MMI to either PIC or SA Home Loans, it was decided that the session be withdrawn or rescinded.
Sorry, who made that decision?
So it was the discussion with the CEO. It was myself, Mr. Nesani, and the CEO, Dr. Machile. The rescindment letter, which is attached as Annexure G, was issued on the 10th of May 2016, and the reason for rescindment was stated as follows. To the extent that there is no funding arrangement mandate, whether expressed, tacit, or otherwise between the servicer or the borrowers and MMI or any external arranger, the lender hereby wishes to withdraw and rescind the letter and or any other correspondence in relation to the arranging fees. From the documentation provided by Mr. Maponya, which include minutes of the deliberations of the SA Home Loans Board on the same day, the Board of SA Home Loans had an extraordinary meeting to discuss the same issue, and it was noted that the session was withdrawn, that all invoices rendered by MMI to SA Home Loans would be withdrawn. To date, no payment has been made by PIC to MMI, albeit there have been numerous letters and an invoice from MMI received, and recently the court summons demanding the fees. My understanding of the litigation is that MMI contends that the arranging fees are due and payable by PIC to MMI, owing to a tacit or verbal agreement between the parties.
Thank you. Did you manage to have a look at the particulars of claim in this case?
I did. I have been provided with the particulars of claim, and from the particulars of claim, the point of contention is that they have MMI is entitled to the fees according to the session that was agreed between them.
But anyway, that dispute is not for us.
Indeed. Mr. Commissioner, that concludes the testimony of Mr. Mangalo.
Yes, it seems there are no further questions, Mr. Mogale. You are excused, and thank you for your time and giving your evidence before us. Thank you.
Thank you,
otherwise excused.
Thank you.
Mr. Commissioner, Mr. Raja is here and is ready to proceed with his testimony.
Yes, Mr. Raja, you are also familiar with where you're going to be, but unfortunately we have to have you take the oath. Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? So help me God.
So help me God.
Thank you very much. You may be seated.
Mr. Raja, before you start with this testimony, can I take you back to last week? There were a couple of questions that I had that I didn't finalize myself, so my apologies for that. I just want to understand a little bit around this transaction fee that was paid. The question for me was the transaction fee that the PIC paid, a 1% transaction fee, and which was supposed to be, also the PIC was supposed to receive a transaction fee of 1%, which was about 23.5 million, that related to the deals done with MMI, and it was split with Maponya and the PIC. Can you explain why it was split?
Through you, Commissioner, when the transaction was done, we had agreed with Mr. Maponya that we will agree on who the service providers will be appointed for technical due diligence, the financial due diligence, the valuations. But however, we expect him to pick up the costs until the transaction is concluded, at which point we would pay him the 1%. I think it was roughly 11.75 million, if I'm not mistaken, as a recovery, a reimbursement of the costs on his side, and we would take the normal participation fee that we charge. So we also took a fee. So that was the arrangement with him.
But surely the PIC earns a fee that is for doing the job, and the question for me would be, how often do you do this, that you have a transaction fee? I mean, there are costs involved, but that's usually part of what the loan is, and then it is repaid or whatever. This is actually part and parcel of you providing, this PIC providing the funding, and you get a fee for doing the transaction. So why would the beneficiary of the loan get a fee, a transaction fee? I can understand them having incurring costs, and then that becomes part of the loan. But why would you split your fee? So in essence, you're getting half the funding that you would normally get, or is this something you do more regularly with other people? How often do you split fees?
Through your Commissioner, in this particular case, we had agreed that Mr. Maponya must carry the costs of the transaction pending the approval. So the financial due diligence, the technical due diligence, and the valuation. So he had paid for that. So when we had paid him the fee, it was also for the recovery of those costs that he carried in his capacity, the MMI. So the fee and then the fee that we took basically carries also our internal costs for ourselves, which is normal. But in this case, it was a reimbursement for costs that he would have incurred and taking on the risk, because if the transaction was not approved, we would not refund him the money.
In your document, your engagement letter, paragraph 322, MMI would be responsible for expenses. Why would that change?
Through your Commissioner, in this particular instance, we didn't want to carry the risk that if the transaction was not approved, that we are sitting with the cost. So we made him carry the costs first, and we had agreed that he'll be entitled to a fee as a recoupment for those costs.
So do you do this normally with transactions? It's quite often that you say you earn a fee of 1%, but in fact you split it with the person who's getting the loan, or the entity that's getting the loan.
Commissioner, so the most often what we would do is that we would charge a fee, the entire fee, but the fee that we charge the client will carry the costs, but we'll recoup it from the fees that we've charged the client. So that's the most common way we would do it. In this particular instance, we took the view, let him carry the risk first instead of us carrying the risk. But in most cases, we carry the risk. In this case, we made him carry the risk.
So he's paid for carrying the risk to get his own loan?
For the expenses that were incurred. So if the transaction was not approved, whatever costs he incurred in the valuation and the various due diligences was for his account.
Perhaps you want to come to SA Home Loans.
Yes, I do, Commissioner. Mr. Raja, you can start with your testimony for this.
My name is Rohit Rajda. I'm an adult male. I was employed by Public Investment Corporation on 1 October 2009. I'm Executive Head Impact Investing. I was Senior Fund Principal at the time. A 9 billion rand facility was made to SA Home Loans for the purposes of granting housing loans. I'm a non-executive director of SA Home Loans and SAHL Investment Holdings. I was appointed on 13 June 2014. The investigating team of the Commission of Inquiry requested I provide the Commission with the facts in relation to a 0.5% on 9 billion rand fee of 45 million rand plus VAT demanded by Matomi Maponya Pty Limited pursuant to PIC approving a 9 billion rand loan facility to SA Home Loans.
Sorry, what is the PIC's shareholding in SA Home Loans?
PIC shareholding is 25%, and we had funded the BHC consortium, which is led by MMI or Mr. Maponya, for the balance of the 25%.
It's 25% each.
It's 25%.
And that's the same amount that was reflected earlier, 960 million.
Yes, 960 million, 480 million direct equity by ourselves, and a loan to the BHC consortium of 480 million.
And just a question there, so that amount, was it injected into the company or it was a sale of shares?
It was a sale of shares where JP Morgan had held the balance of the 50%, and so this was an acquisition of the 50% shareholding held by JP Morgan. Unless otherwise stated, whenever mention is made of PIC, it refers to PIC acting as agent on behalf of the Government Employees Pension Fund, or the GEPF. MMI requested payment of 45 million rand plus VAT for work done in conceptualizing the GEPF member benefit and affordable housing program and facilitating the funding of 9 billion rand. MMI claimed that the fees from both PIC and SA Home Loans, but the latter parties have denied liability, and the matter is currently subject to litigation.
When you say the latter parties have declined, both of them?
Both PIC and SA Home Loans.
Did the company sort of provide documentation about this concept, the benefit and affordable housing programs? Did they take you through the concept and provided documents on that concept?
Through your Commissioner, the consortium did provide us with documentation, but the one other part I wanted to add to this, which I had omitted in my statement, is that Mr. Maponya had mentioned that in his discussions with Dr. Majila at the outset of the transaction where the 480 million or 960 million was done, when there was an acquisition of the JP Morgan shares, that the understanding was that they would share, initially he had come to PIC to fund the outright purchase of JP Morgan and PIC not to have a shareholding. But Dr. Majila had mentioned that that was not how he wanted to see it. He wanted PIC to have 50% of that share, that's the 25. And so there was an understanding that going forward, that they would share in even whatever fee was earned. That's, I have not verified that, but that is what was told to me by Mr. Maponya.
Did you ask Dr. Machila about that?
No, I did not verify that with Dr. Majila.
And at what point, at any point in time, did you ask Dr. Machila what the arrangement was with Mr. Maponya?
Look, in later times when this thing became the subject of dispute, Dr. Majila indicated that he doesn't have the authority to, in any event, to agree anything, because that is always subject to a committee. But what he did mention was that the understanding was that that Mr. Maponya would come into the transaction on the understanding that they're there to grow it and to look at moving into the affordable housing space, as well as providing products for GEPF members. But that's all he had mentioned. But he was quite clear that he did not agree. But this is something that we only, that was only later on in my discussions with him that he mentioned that.
In essence, he said it was about the business case rather than about any agreement about fees and whatever.
Yes, he said he did not agree. any such.
And the 45 million, as we heard earlier, is a 1% of the total 9 billion, not the 0.5% or the 50
Yes,
basis points.
Through you, Commissioner, yes, it was 1%. However, when the matter was discussed with Mr. Kevin Penwarden, who was the CEO of SA Home Loans, as well as Mr. Rob Kelso, who was the CFO at the time, they felt that 1% would be too high and it would defeat the purposes of providing a competitive rate for GEPF members, because that would have to be imputed in the pricing. So hence they had negotiated, and eventually it had come down to 0.5%.
Paragraph 5 still talks about the work done. So were the documents, sort of produced by the company saying this is the work done by us and you need to pay us something for that? The concept.
A documentation was provided, but there was never an agreement that that would be the basis of payment of the 45. They would undertake that work, but we never concluded any service level agreement with them or any engagement letter with the company. This statement is intended to provide the sequence of events which has occurred in relation to this fee demand of 45 million. On 12 September 2014, the CEO of SA Home Loans, Mr. Kevin Penwarden, the CFO at the time, Mr. Rob Kelso of SA Home Loans, met with Dr. Daniel Majila, Mr. Wellington Masikesa, and I at PIC offices to discuss the funding line referred to above. Subsequent to these discussions, documentation was sent to PIC by SA Home Loans. Mr. Benedict Mongalo from the Impact Investing Division led the investment team on the transaction. On 18th November 2014, the Portfolio Management Committee of Unlisted Investments granted permission for the transaction to proceed to the due diligence phase. After the due diligence was completed, the investment team compiled an appraisal report. During this due diligence process, Mr. Maponya indicated to me that he had agreed with the PIC CEO that he would be entitled to half the fees charged on the transaction for the work that had been done. I communicated this to Mr. Benedict Mongalo, and he accordingly included such information in the appraisal report.
Sorry, did he include, in essence, what is confusing for me about this is you say he included it in the appraisal report, but was that something that you said, this is what he is claiming, or was it something that you said, look, this is what we had agreed? Because I'm not sure from that wording whether what you said to be, when you spoke to Mr. Mongalo, that it was to be conveyed that this is due. I mean, was it something that in the documentation you actually said, this is what he is claiming, but there is no foundation to it. We are simply informing you that this is a claim. Or did you say this is a claim that we must be aware of?
I had mentioned to him what Mr. Maponya had mentioned to me, that he had agreed with Dr. Majila that there would be this fee sharing arrangement. That is what I had indicated to Mr. Mongalo.
So anybody is able to say, I had a conversation with the CEO and I can claim 40 million, 50 million, 100 million, or whatever it is that I want. And you then put it into documents without any documentation to show it.
Commissioner, in this particular instance, we had put it into the document, but it's serving at a committee where Dr. Majila is a member. But also, I'm mentioning it to Mr. Mongalo. Normally, because he's leading the transaction team, I don't know whether he had spoken to Dr. Majila about this, but it is something that would have, in any event, been, Dr. Majila would have been aware of when it came to PMC2.
What I'm trying to understand is, if anyone came to you to make that assertion, why would you give it validity? is it something that happened quite often, that there was a verbal agreement with Dr. Machila, that somebody can come along and say, oh, I agreed this with him and it's worth 45 million to me, and then it's given as fact? How would that be accepted into any discussion without documents, without letters, without formality? This is not small money. It might be small to the PIC, but 45 million is not small money. So I don't understand how, unless it is a frequent occurrence, that people can say, I've had a discussion with the CEO, and therefore it's become normal for you to include it, because that happens often. If this is a rare occasion, it would have been something that you simply said, hang on a second, give me the documentation, and you dismiss it out of hand without documentation. So I'm trying to understand why this got the legs it got.
Commissioner, firstly, I'd like to say that it is not a frequent occurrence. It was just information which Mr. Moponia had mentioned to me, and given that Mr. Mangalo is the lead on the transaction, I had communicated to him. I would have taken it that he would either have had discussions with Dr. N and/or this would have been tabled at the PMC. So, but I did not have any one-on-one discussion with Dr. Majila to verify that. And I can't speak for whether the investment team had validated that with Dr. Majila.
If I understand you correctly, you say you assumed that Dr. Machila would be at the committee meeting that would discuss the issue.
Yes, he would normally be the chair. He is the chair of the Portfolio Management Committee. Chair, if I may continue, to the best of my recollection at that stage, Mr. Moponia was under the belief that the fee was 1% of the loan facility. It had in fact been 1% at the outset, but SA Home Loans had negotiated it down to 0.5%.
Did you advise him of that?
Not to my knowledge. The appraisal report was presented to PMC Unlisted Investments on 9th April 2015. The terms and conditions of the funding and the proposed fees was accepted. PMC requested that the appraisal report, modified to the extent necessary, be sent to PIC's investment committee for approval. The appraisal report was amended, however, significantly. Whilst the 0.5% fee was still proposed, the report did not state the recipient of the fee. However, usually when PIC is the recipient of any fee, the report does not usually state this, as it is taken as given that it is for the benefit of PIC. The IC approved the loan facility on 14 July 2015.
Sorry, do you know if there was any discussion in that committee meeting about this claim?
Through you, Commissioner, in the meeting of the IC, the fee, it was silent. It just, within the table of all the terms and conditions, it had just said an upfront fee of 0.5% was payable. But usually in a table of that sort, it is taken as given that it is to PIC.
Does this mean that the investment committee didn't know who this fee was going to?
It would have been understood that it is to GEPF, to PIC on behalf of GEPF. So when the approval was done, there's an approval where there is no fee approved to MMI. That's the approval. The final approval is an approval of a fee of 0.5% payable to PIC.
0.5%? I mean, 50 basis points, because just now you said
Yes.
0.25.
0.5%.
0.5.
So one can say that it was assumed that this fee goes to the PIC, given the convention, basically.
Yes, it is to the PIC, because even in the carrying out of the legal agreements, it is stated explicitly to the PIC.
So Dr. Machila was in that meeting, and there was nothing reflected in the decisions that would say this fee is split or it is going to a third party. it was absolutely taken for granted as the normal course of events, a 50 basis point fee would be going to the PIC.
Yes, I'm unable to confirm whether he was in the meeting, but that we can check the minutes whether he had attended. The legal agreements, with the main agreement being the Master Loan Facility Agreement, was concluded on 24th December 2015. Clause 16.7 of this agreement states the following insofar as the fees are concerned. The borrower and servicer shall pay to the lender an arranging and underwriting fee in the amount equal to 0.5% of the GPF facility, which fees shall be exclusive of VAT. The arranging fee and underwriting fee shall be due on the effective date and may be capitalized to the total capital and be repayable in accordance with the priority of payments. It is clear from the wording of this clause that the fee is payable to GPF and not any third party. Also, the proposed fee is intended to be for the account of the borrower. It is considered to be part of the borrowing and not a cost for the GPF. Mr. Maponia told me that when he inquired with Mr. Mongalo about the fee, it was pointed out that the PIC approval did not include any fee payment to MMI. I initially thought that the fee was approved at IC, but later confirmed Mr. Mongalo's understanding.
Why did you think that? What led you to think that the fee had been approved? It wasn't in the memo to say approve the fee to Mr. Maponia?
Yes, because normally what would happen is that when we take the appraisal report to the PMC, usually when there is not much changes proposed, all we would do is we would submit the same report to the investment committee without modification. So I think even myself, because I recall at some point I had been under the impression that it was in that report, but it wasn't. In order to address this matter, Mr. Mongalo prepared a submission which both him and I signed to the PIC's investment committee to indicate that the fee of 0.5% payable to the GPF had been intended to be the benefit of MMI.
On what did you base that? Everything that you've said so far, on what did you base writing a letter of that nature to say that it is for the benefit of MMI? Because he said so?
Through you, Commissioner, now it goes back to the first submission to PMC where it was agreed that the fee would be 50-50. That was the understanding. Now, Mr. Maponia is still claiming that 50 basis points is due to him. Remember, he is still under the impression that it is 1%. And so...
But you're endorsing and saying, indicate that the fee of 0.5% is payable, so you're endorsing his understanding of 1%. I mean, if he is correct, and it does belong to him, which is doubtful from what you've said so far, but that is for a court now to decide, but it should only be of what the agreement was, which is, if you were endorsing it, saying it was 1%, it was not agreed at that, we finalized at 0.5, if he's getting half of it, it's 0.25, but you're endorsing here, you say, a 0.5% payable fee, because he says so? I want to be in those kind of positions, I'm sure many others will come along and say so.
Commissioner, as I mentioned at the outset, this was based on the understanding that I'm accepting that the discussion between him and Dr. Majila, which I had mentioned at the outset, was that the fee would be shared 50-50 and it was on the basis of 1%.
But before you write a letter, don't you then go and check with Dr. Majila? I mean, this is not credible to me, I'm sorry. It's either something that you say it's given because somebody says so, you go and endorse a 45 million fee without checking with Dr. Machila whether there was any validity to it, given that you have submitted to the meeting where he is present.
Through you, Commissioner, as I mentioned earlier, is that I passed on what information was given to me, to the transaction team, and specifically Mr. Mongalo. So usually what would happen, I would not normally be the one engaging to validate these. So as I said, I don't know whether there was a discussion with Dr. Majila on the fee, but it having served at the PMC, and the fee was accepted there, that we said we'll take it with the disclosing to the IC what exactly happened and what is being said, and it's for the IC to decide whether to approve or not approve. Because we had no basis to engage with Mr. Moponi or pay or discuss anything on fees, because strictly speaking there was no approval at the investment committee. However, the CEO did not recommend the submission to the IC, and presumably because any payment of fees was for the account of the borrower and therefore had no financial impact in terms of PIC's delegation of authority framework. However, this would need, I'm presuming, this is something that Dr. Majila would need to confirm. But shortly after that memorandum, I think it was on the 26th of February, but on the 27th of February, the CEO advised Mr. Mongalo by email that SA Home Loans should pay MMI directly, and I attached that as Annexure G. Accordingly, Mr. Mongalo consulted PIC's Executive Head of Legal Counsel, Mr. Ernest Nasani, who advised that the Master Loan Facility Agreement would have to be amended to take this into account. Thereafter, Mr. Nasani had engaged the PIC-appointed legal firm on the transaction, that is DM5, to prepare an addendum to the Master Loan Facility Agreement, but the parties could not yet reach agreement on the wording of the amendments, and consequently no addendum was done.
Parties being home loans?
Being SA Home Loans and PIC. Based on an email correspondence between representatives from SA Home Loans, PIC and MMI, there was discussion that the fees payable to GEPF in terms of clause 16.7 of the Master Loan Facility Agreement could be effected through the clause dealing with cession as stated in clause 16.13.2. This clause states as follows. GEPF or any person or entity to whom its rights and or obligations are ceded, delegated and or assigned in terms hereof shall be entitled on written notice to the borrower and SA Home Loans to cede, delegate and or assign all or any of the its rights and or obligations hereunder, either absolutely or as collateral security to any other persons or entities, notwithstanding that their cession or assignment to more than one person or entity may result in a splitting of claims against the borrower and or SA Home Loans. And on any such cession of assignment taking place, the borrower and SA Home Loans shall, if so required by any cessionary, make all payments, the right to receive which have been ceded to such cessionary, and perform all obligations hereunder, the right to which have been ceded to such cessionary, directly to such cessionary. Essentially, as pertains to the fees, the clause allows GEPF or its designate to request the borrower or SA Home Loans to pay the fees to a third party specified by GEPF or such designate. On the basis of this clause 16.3.2, on 29th April 2016, PIC issued a letter to the CEO of SA Home Loans and copied Mr. Maponia. This letter, which I shall call a session letter, authorizes SA Home Loans or the borrower to cede the fee of 45 million rand payable to PIC in terms of clause 16.7 to MMI. Also, the letter requires the borrower to repay this amount to PIC. However, prior to the issue of the cession letter, MMI demanded payment of 45 million rand from SA Home Loans. SA Home Loans pointed out that there was no legal basis on which to pay the fee to MMI, as there was no specific clause which specified that payment must be made to MMI. Mr. Kevin Penwarden, the CEO of SA Home Loans, proposed that in the absence of an addendum to the Master Loan Facility Agreement, the only way payment to MMI could be done was through PIC issuing a cession in terms of the said agreement. This message was communicated to PIC's legal division, after which the cession letter was issued. At a SA Home Loans board meeting held on 9th May 2016, the matter relating to the fees was a source of heated discussions. I had proposed that the matter relating to the fees be a matter discussed between PIC and MMI, and decided that we will withdraw the cession letter. The board agreed with this, but the Standard Bank nominated director on the SA Home Loans board, Mr. Larry McCarthy, requested that if PIC agreed to pay MMI a fee, then such must be disclosed in writing to the SA Home Loan Board, and agreements related thereto would be referred to the shareholders for ratification. The following day, that is the 10th of May 2016, a letter of even date was sent to SA Home Loans and MMI, which stated that to the extent that there is no funding arrangement mandate, whether expressed, tacit, or otherwise, between the servicer or the borrowers and MMI and or any external arranger, PIC rescinds the cession per the cession letter. It has been established that there is no funding arrangement mandate, a formal mandate concluded between SA Home Loans and MMI. Mr. Maponya contested this, and after obtaining legal opinions, it was agreed that the cession cannot in law be unilaterally rescinded, but requires MMI written consent. Again, this matter became a source of heated debate, and at another meeting of the board of SA Home Loans, I implored Mr. Maponya to agree to PIC's rescindment of the cession, which he eventually acceded to in the meeting. MMI subsequently issued a letter dated 4th November 2016, agreeing to the rescindment, as well as withdrew its demand for the fees. On 11th April 2019, MMI...
Sorry, just for clarity around dates, so that took about from April to November for that to be rescinded?
Yes.
And then the matter and withdrew, and you have that in writing as per Annex L, that he has withdrawn and withdrew the demand for the fees as well?
Yes.
And it is now in court 3 years later? 17,
Yes.
18, 9, 7, well, 2 and a bit years.
Yes, it is in court.
Was there anything that occurred in that intervening period between November 2016 and April 2019? Were there any interactions between you? Were there any further correspondence? Where did the matter lie in that intervening period?
Yes, in the intervening period, the matter rarely ever came up. And even when Mr. Maponya did raise the matter, it wasn't with such vigor or conviction as he had before. So we could say, by and large, since that, for him agreeing to that rescindment, it had been fairly quiet between the parties. Nor, if I recollect, I don't think it ever even came up at a board meeting of SA Home Loans, not to my recollection. But my understanding is that the reason why it has come is because, and I'm not a legal person, but I understand after 3 years, the debt prescribes. And I think this is meant to keep it alive. On 29th April 2019, I attended an Audit and Risk Committee meeting of SA Home Loans. At the meeting, Mr. Kevin Penwarden presented a report to the meeting. In this report, he indicated that 2 directors of SA Home Loans had engaged with one of the members of his senior management on the matter relating to fees. The report states that the two directors had indicated that a further 10 billion rand facility could be procured for SA home loans, provided a fee of 0.95% of this facility could be procured. This fee...
Sorry, just before you proceed, they engaged with one of the members of his senior management, this is the home loans management, on the matter relating to fees. This is other fees, nothing to do with the MMI fee dispute?
Okay, so if I finish that one sentence, and I will address that, Commissioner. This fee would incorporate the 45 million that has not been paid. So if you unpack the 0.95%, it would be 0.5% of 10 billion. And if you take 45 million rand as a percentage of 10 billion, that's 0.45%. So it comes to 0.95%. So this is what the CEO of SA Home Loans is saying. This is disguising the way in which to bring back the 45 million.
And who would the loan be from?
The loan would be directly from GEPF. So our understanding is that they would procure the loan, a further facility of 10 billion from GEPF.
And it's a new facility?
A new facility.
Okay.
Sorry, just in relation to that, did you discuss this with the GEPF as to whether there was in fact the possibility of a loan and that this was in fact a way of paying a fee that was improper?
Through you, Commissioner, just to state first is that the matter with regards to GEPF and the funding of SA Home Loans, we had discussions with GEPF, but probably about 6 months ago, where GEPF indicated that the 10 billion, that the initial funding was a once-off, and there was never an intention to continuously fund GEPF.
Initial funding, that which you gave to home loans in that initial investment.
Yes, that it was a once-off. That there was not an intention that would have been a first of many commitments. So we were quite clear on that. However, with regards to this particular fee, we have not discussed that with the GEPF yet. This is a matter that is going to be subject to further discussion at tomorrow's board meeting of SA Home Loans, because the two directors have denied the version of events from the CEO of SA Home Loans. So subsequently, Mr. Penwarden shared his report with the board and shareholders. Mr. Penwarden also reported the matter to the auditors, that is the SA Home Loans auditors, who have submitted a report to the Independent Regulatory Board of Auditors in terms of Section 45 of the Auditors Professions Act of 2005. The auditors have provided the directors of SA Home Loans until the 30th of May 2015, it should read, 2019, to respond to this reportable irregularity as defined in Section 45 of the aforesaid Act. Both directors have denied Mr. Penwarden's allegations and have requested a meeting of the board to present the case. This meeting is scheduled for the 22nd of May 2019.
And I'm assuming that the two directors that are referred to, neither of them are the PIC representatives, including yourself?
One is the PIC representative.
The other PIC representative, or you?
No, it's the other PIC representative. And
just remind us who that is.
Mr. Wellington Masikesa.
He's the executive in the, yeah.
And then it is one representing the BHC consortium.
So it's basically Mr. Maponya and the PIC?
Yes.
Can you please explain paragraph 27 again, please? 27? Why this reporting to IRBA?
Okay, it's long since I've engaged with this particular section of the Act, but what basically happens is the auditors, in the conduct of their duties, if they come across any potential irregularity defined in this section 45 as a reportable irregularity, what they have to do is within 3 days of becoming aware of that irregularity, they have a duty to report this to the Independent Regulatory Board of Auditors, and then the Independent Regulatory Board of Auditors would give you a certain amount of time within which to come back and state whether is there definitely, because it's at that point when it's reported, it's not reported on the basis that it's proven beyond reasonable doubt that irregularity is taken. It's a judgment call. But they give you a certain amount of time to come back and confirm whether there is an irregularity or not, or there was an irregularity and it has been resolved, or there is an irregularity and it's continuing. So that's what you have to come back and report to them on. Now they've given us to come back to them by the 30th of May. So a meeting tomorrow at the Board of SA Home Loans is for us to deal with that matter so that the board can also issue a response to the auditors who will then report to the IRBA.
This 0.95% fee, is that the whole issue there?
The issue is that it comes back to the 45 million. That the 45 million we say is not payable, but it is. We are saying if you say that you're going to agree on a fee of 0.95% of the new facility, what it's saying is that when you unpack that 0.95%, you're just finding a backdoor for the 45 million.
That's fine, thank you.
Thank you, Commissioner.
Yeah, just explain to us in terms of fees and how the PIC sort of looks at fees, you know. When you do a DD, I mean, do you charge fees? Do they go to the PIC or do they go to the GEPF? Because one normally thinks that the sponsor would pay transaction fees because they do the memo valuations and the other things, you know. Just explain to me that what typically happens, especially when the PIC stroke GEPF must get the fees.
Okay, what would happen is that when we go to PMC1 and we request permission to proceed to due diligence, once that is granted, we would enter into an engagement letter with the client. What we would, in most cases, we would do is that the default position is we'll always charge a 1% fee to the client. But that fee is there to recoup our costs. It's not intended to be part of the return. It's there because in most instances, we would take the risk on the investment. We would commission the legal due diligence, the financial due diligence, the commercial, the technical, and the legal and regulatory due diligence. We would commission that. So hence we would charge that fee, and that fee from time there are cases where we'd capitalize it to the loan. So it means it's got to be repaid to us. That's how we do it.
So meaning that you could have the 1% fee that you charge as the PIC in the loan, and the client must have an advisor too. So they would have fees which are either paid or they are charged within the loan too. Is that correct?
Yes, the client has to appoint its own advisor. Normally, I mean, that's the expectation is that they have to have their own advisor. But there are cases where, for example, in the renewable energy space, you would have everybody agreeing for example, the banks would normally be on the debt side, the PIC would be on the equity side. So we'll all jointly agree on which service providers to procure. And the fee arrangement will be one way agreed by everybody. So it varies from case to case, but by and large, as I described earlier, that's the most common way of doing it.
So meaning typically you might have the PIC fee, the 1% within the debt, and you could have another fee, from the sponsor within the debt also.
Yeah, the sponsor could also be incurring fees.
Does the sponsor have to get the permission from the PIC to include the fee within the debt structure?
Yes.
Yes.
Yes. Typically what we would do in the engagement letter, we would give them the option of it being capitalized.
Can I just ask one question which may or may not, you may not. Are municipalities allowed to borrow? Can you lend to municipalities?
Commissioner, as far as I'm aware, municipalities may borrow, but they got to follow the Municipal Finance Management Act, the provisions in that act, which I'm not too familiar with.
Okay.
Mr. Kue, any further questions?
I have no further questions, Commissioner. And I think it would be an appropriate time to take a tea break.
Shouldn't we excuse Mr. Raja first?
We can do that, Commissioner.
Yes, thank you, Mr. Raja. Thanks again. I mean, the same comments apply that I've, given you in the last occasion. We might see your face back here again. We're not sure of that, but thank you so much so far. All right.
Thank you.
Thank you. You're excused for the day. We'll adjourn until 22:12.
Mr. Commissioner, members, we are ready to proceed. Our next witness is Mr. Sello Adson Matar. He is ready to take the oath. Just push the red button there.
Good day, Mr. Matar.
Good day,
Are
Commissioner.
your names Sello Edson Matar?
That's correct, Commissioner.
Do you have any objections to taking the prescribed oath?
Not at all.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you very much. You may be seated.
Thank you.
Thank you, Mr. Matar. If you will just speak into the microphone and please speak up. You have prepared a written statement for the benefit of the Commission. Is that correct?
That's correct.
And you have offered to come here voluntarily. It was not necessary to subpoena you.
That's correct.
Can you please then, and the last matter, the statement was prepared by yourself,
That's correct, evidently.
and you confirm the content as the truth and correct.
That is correct.
Please proceed.
Thank you. My background. I'm a 46-year-old male, chartered accountant by profession, having qualified as such on 31 December 1999, after completing articles of clerkship with KPMG in Johannesburg office.
Did you say 1989 or
1999.
99?
1999, Commissioner. I hold a Bachelor of Commerce degree in accounting from the University of Witwatersrand and a higher diploma in accounting from the University of Natal. I was employed by Eskom Holdings SOE Limited as head of compliance in its treasury division for a period of 2 years, and at ISCO Limited as assistant treasurer for about 16 months. Left ISCO after it was taken over by LNM Holdings, later ArcelorMittal, at the end of August 2003. 1 September 2003, I joined KPMG as audit partner in the Financial Services Division, Johannesburg office. I was also appointed as director of both the audit practice as well as the advisory division. On 30 June 2008, I resigned from KPMG to pursue my entrepreneurial aspirations. Currently, I'm a non-executive director of Lanseria International Airport and its subsidiaries. I was appointed as transaction advisor on that matter by the PIC Consortium, and due to my in-depth knowledge of the entity, was subsequently recommended for appointment to the board of Lanseria in October 2013 by the Public Investment Corporation, and was appointed by the shareholders in October 2013 as one of the 2 independent representatives on that board.
Sorry, Mr. Matar, could you just elaborate a little bit when you say you were the transaction advisor on that matter? Can you just tell us what that matter was?
So on the Lanseria Airport transaction, so in 2011, Commissioner, a consortium led by Nozala made an offer to buy Lanseria International Airport, and they approached PIC for funding, and that transaction was concluded in 2013 on the 30th of June with PIC as a shareholder, Harith Fund Managers, and the BEE consortium led by Nozala Investment Holdings. I'm an executive director at Tego Capital, which I founded and have been a director since its incorporation in 2009. TECO provides corporate and project finance advisory services in various sectors of the economy. It also makes principal investment in certain instances. Our main focus is to provide advisory services on projects that have a high impact in achieving a positive social change. We've done good work in this area over the past 10 years as an emerging advisory firm. In particular, some of the advisory mandates we've successfully concluded and delivered on since our establishment include Kalahari Manganese, Lanseria International Airport, Clinics Healthcare, etc. As a founder and executive director of TECO, I'm authorized to depose to this submission and appear before this commission to provide additional information and clarity on the subject matter not adequately covered by this statement if the chairperson deems it fit. Facts contained, unless otherwise stated or indicated, are within my own personal knowledge. Information that has been highlighted in gray is confidential because the current beef remains ongoing. Current beef transaction remains ongoing. However, I understand that there were developments yesterday where some of the information, financial and otherwise, of current beef was spoken about yesterday in public. So I think when we get there, I'll be guided by the Commission as to how we approach that section of the submission. The purpose of this submission: I'm involved in both the current beef transaction and export trading group transaction. Current beef transaction, TECO is a transaction advisor represented by me. In the export group transaction, TECO is the originator of the transaction represented by me, and approached the PIC to apply for funding. Because of my involvement in both transactions, I've been asked by the evidence leader, Advocate Lebe, to testify at this commission on the following issues.
Mr. Matar, so are you an advisor to the BEE consortium?
That's correct, sir.
All right.
Okay. The allegations made against me personally in the James Noko email on 30 January 2019, an email was written by known whistleblower James Noko, was circulated on social media, which made references to a number of allegations against me in relation to the current beef transaction and its promoters, certain improprieties linked to the former CEO of the PIC, Dr. Dan Machila, non-executive director of the PIC, Ms. Dudutla Choyo, and certain senior politicians, Mr. Mashatile and Gungubele.
Can you please do me a favor and pull the mic a little closer to you?
Okay, thank you. I'll do so, Commissioner. In the current beef transaction, on the valuation, the allegations made regarding the transaction in the James Noko email and the governance process followed by the PIC in that transaction. So the evidence leader requested that we speak about the processes followed from the beginning to the appointment of that particular transaction.
Just briefly, can you just tell us what James Noko is saying about you in particular, in summary? Is it covered somewhere? Or?
It's covered elsewhere on page 6.
Mm-hmm. Okay.
If I can deal with it when we get to page 6,
that's
Commissioner.
Fine.
Thank you.
That's fine.
I spoke about export trading group transaction as originator. So evidence leader wanted to understand the processes followed beginning to end in terms of those two transactions. In addition to the James Noko email dated 30 January 2019, there was also an email from James Noko which was sent towards the end of August 2018. The August 2018 email makes the same allegations as the 30 January 2019 email, but implicates additional people. The August email is attached here to as annexure KB1. I don't have the annexure with me, but it is somewhere. And this email was sent as soon as the investment committee of the PIC gave final approval on the current beef transaction. At the outset, I wish to put it on record that I categorically deny all allegations leveled against me by James Noko as being without foundation and without substance and simply intended to defame and tarnish my good name and that of TECO. Furthermore, I wish to state that my involvement with the PIC insofar as it relates to the current beef transaction is in advisory capacity rather than on an equity participation as alleged in the said James Noko email. The remainder of the allegations contained therein are a fabrication and not based on any truth or evidence. I'm not aware of any credible evidence that support the allegations made in the James Noko email. Despite that, this commission despite this commission providing ample opportunity for him or anyone with credible information to come forward. Nevertheless, I want to respond to the allegation leveled against me and assist the commission in its investigation. I therefore want to state the following. I'm not involved in a romantic relationship with Ms. Dudu Tlhatswayo, and I've never had such a relationship in the past. Met Ms. Tlhatswayo when she was appointed to the board of Lanseria International Airport on 25 September 2014. Cordial business relationship with Ms. Tlhatswayo and have socialized with her in a business context. For example, I do play occasionally golf with a number of fellow golfers, and I've on a few occasions played golf with Ms. Tlhatswayo. I'm not a shareholder in any ownership structure of the proposed current beef transaction. TECO in particular, and in particular my role is that of transaction advisor. To the best of my knowledge, the current beef price was not inflated. An independent valuation, which I have, was done by one of the leading investment banks in the country, being Rand Merchant Bank, and they provided a valuation range to the consortium. I understand that the PIC also performed their own evaluation internally. However, I've never seen that valuation. The final price was agreed with the seller after extensive negotiations.
Just to check, in terms of the RMB valuation,
Yeah.
who was it done for and who paid for it?
The RMB valuation was done for the PIC and the consortium because those are the two parties that have joined forces to buy current beef, with PIC owning 70% in the SPV and the B consortium owning 30% in the SPV. RMB basically agreed to do the task on risk. Yes. Further, I was not appointed to the Lanseria International Board to help Ms. Dudu Tlhatswayo. I've been on the board of Lanseria since October 2013, since 31 October 2013, as a permanent member, and Ms. Dudu Tlhatswayo was appointed on 25 September 2014 on a 2-year rotation basis. I was never appointed to the KZN Growth Fund by the PIC, but rather I was appointed to the KZN Growth Fund by the MEC of Economic Development in KwaZulu-Natal, Mr. Mike Mabuyakulu, and I served for 12 months as chairman of Audit and Risk Committee. The rest of the submission deals with my involvement as transaction advisor on current beef and TECO's involvement as originator in the export trading transaction.
Can I just ask you, and if you are going to cover it, let's cover it somewhere else,
Yes.
about the valuation. Yeah,
It's covered somewhere else.
it's covered somewhere else.
Yes. Current beef operates the largest cattle feedlot and abattoir on the continent and is the largest single-phase feedlot and abattoir in the world. The company was founded in 1974 by the Current family and is based in Heidelberg for the feedlot, Balfour for the abattoir, and City Deep for the distribution center. The feedlot accommodates 150,000 head of cattle at any given time. The Balfour-based abattoir is licensed to process 2,200 head of cattle daily. South Africa is current beef's single largest market, but it also has a substantial export market to China, United Arab Emirates, as well as North Africa. Current beef is controlled by Mr. and Mrs. Curran and owned entirely by the Current family. The business of current beef comprises current beef being the sales, marketing, and the abattoir business owned by the family trust, as well as the feedlot, which is the farming operations owned by Mr. Ivo Curran as a sole trader. We call them collectively the sellers herein on. My involvement in the proposed acquisition of Curran started during September 2017. One of the transaction promoters, Mr. Reggie Kukamo, approached me as a director of TECO to be transaction advisor in the proposed acquisition of current beef. by Black Economic Empowerment Consortium he was leading. Prior to TECO's involvement, a funding application for the transaction had already been submitted to the PIC. They needed a transaction advisor to help with the structuring and coordination of the entire deal process. As part of client acceptance procedures, I inquired how the transaction had originated and how the various role players were involved in the deal. Based on my discussions with the promoters and review of available correspondence, the transaction came about as follows. Shareholders of Current Beef were in discussions about a potential transaction with a foreign company. Mazi Capital came to know about the potential transaction through Johan Pretorius, who is related to the CEO of Current Beef. Johan is a former colleague and a friend of one of the directors of Mazi, Khapum Patlele. Understand that Johan mentioned a potential foreign transaction to Khapum Patlele, who requested Johan to facilitate a meeting with Current Beef to talk about the possibility of Current Beef being sold to a local consortium of investors so that the ownership is retained in South African hands. Understand that Khapu then approached the PIC about Current Beef as a potential investment by the PIC and a Black Economic Empowerment Consortium, represented by the promoters, I think there's a typo there, Regi Kukama and Malungelo Zilimbola. This is due to the strategic role that Current Beef plays in the economy as the leading supplier of beef in the South African market, and how, if it's not acquired by a South African company, it could create a crisis in the local market from a food security perspective in the long term. Understand that Khapum Patlele gave the PIC contact details of Current Beef to request meeting and discuss possible investment by the PIC and a Black Economic Empowerment Consortium. A number of discussions between Current Beef, the PIC, and the consortium took place at the Current Beef feedlot in Heidelberg between July and September 2017. Understand that they reached an in-principle agreement that the PIC and the consortium would be given a chance to do a comprehensive due diligence review and valuation of Current Beef.
Do I understand correctly, Mr. Matar, that at this stage you were not on the scene?
I was not on the scene, Commissioner.
When you say I understand, I suppose you're talking about information that you got, or do you know these as facts?
I was told about that information, and I've reviewed some correspondence basically between PIC and the consortium dated October 2017, talking about the transaction.
Was the PIC part of the meeting on paragraph 18.4?
That's correct. There were a number of meetings, as I understand, one between the PIC CEO, the then CEO, and the family on the farm, where he brought the team, the deal team from private equity and development investments. There was a meeting between the PIC and the promoters on the farm. I think, I speak under correction, there must have been also another meeting with the deal team only, without the senior people in the transaction.
Okay. Just to check quickly, so the first meeting between the PIC and the consortium, sort of who was there? Do you know who were there? Do you know?
I am not sure. I'm not sure. I think the consortium may be able to provide further clarity on that.
Okay.
Thank you. I understand that the potential transaction with a foreign company was not pursued when it became apparent that the foreign company planned to export the majority of the produce, and the sellers considered this to be a food security threat to South Africa, so they disengaged the foreign company. When TECO Capital started as advisors on the transaction, we requested audited financial statements of Current Beef for the previous 3 financial years, recent management accounts in order to satisfy ourselves that Current Beef's historical performance can support the seller's valuation of 6 billion rands. Also, I may just pause there, Commissioner, to say that valuation of 6 billion rands was based on the offer apparently that they had received from the foreign company. I've not seen it, but that's what we have been told. Engagement.
Just to follow up, is that one understands that the seller actually has been very adamant that he wants the 6 billion rand no matter what. Is that correct?
That's correct.
That, he won't sell below that.
If you look at the valuation further on, we've basically come up with a solution where we can essentially pay a reasonable price.
Okay.
But somewhere when I talk about an indicative expression of interest that was submitted to the seller, originally it was 6 billion rands, he said, this is my price, this is what I'd been offered, and I'm not budging.
Yeah.
The engagement between the consortium and Karam was formalized by submitting an indicative offer, which remains subject to an independent valuation, comprehensive financial, legal, and commercial due diligence review, and approval from the following committees of the PIC: Portfolio Management Committee 1, PMC 1, Portfolio Management Committee 2, and the Investment Committee of the PIC. This indicative offer was accepted by Current Beef, subject to very tight deadlines to finalize the transaction within less than 6 months of accepting the indicative offer. I think, if I recall well, this indicative offer was concluded in early December 2017. With this information, the seller requested a letter of support from the PIC. When I say this letter, I think this was the original letter that had been received on 5 September 2017, expressing PIC support of the transaction. I think there was another letter dated middle of December that PIC wrote in support of the transaction, which obviously made it very clear that that PIC will only participate once there's approval by relevant committees and due diligence as well as valuation. The consortium then went ahead to appoint Cliff Decker Hofmeyer on 5 February 2018 to perform legal and environmental due diligence. Deloitte on 28 February 2018 to perform financial and tax due diligence review, as well as Genesis Analytics on 11 May 2018 to perform what we call a commercial due diligence, essentially looking at the market performance, agricultural sector, underlying assumptions, and basically validating them to prove that once they go into the model, those assumptions make sense. It was agreed between the PIC, deal team, and the consortium that the consortium will appoint and pay the service providers, and that the PIC will rely on the work of such service providers for as long as they meet certain standards in terms of experience, capability, etc. The consortium appointed RMB on 22 March 2018 to perform an independent valuation of Current Beef and work alongside TECO in the final transaction structure and compile a detailed investment memorandum. RMB agreed to work on a success basis, given that the consortium was not in a position to fund costs associated with this stream of work. The final due diligence report from Deloitte was received on 6 June 2018. Legal and environmental due diligence reports was received from Cliff Decker Hofmeyer on 25 May 2018, after 4 months of extensive work and discussions with the Current Beef teams. The independent RMB evaluation was received on 5 June 2018. All 3 reports were provided to both the consortium and the PIC.
Just a question, in terms of TECO, were you guys being paid or working on risk?
On risk.
On risk?
Yes.
Okay.
So the valuation of Current Beef was 5.2 billion rands, calculated as follows. Okay, so RMB used a discounted cash flow method based on 3 scenarios. 1, a conservative scenario, which basically was saying that let's tone down on the assumptions in terms of economic growth, demand, number of cattle sold, and whole range of assumptions. The management case, which is what was presented by the management team as forecast for the next 3 years. as well as the investor case, which is what the B consortium set down and basically considered that, look, this is essentially what this business could do. The valuation
Sorry,
range.
before you continue, is it possible to just give us an idea of who comprised the consortium?
Okay, Commissioner, the consortium comprised of two entities. One was Nguni Holdings, which was wholly owned by Mazi Capital. Mazi is in the financial services industry, so in that structure you've got the promoters, the CEO, CIO, and the whole team basically that works at Mazi and is allocated shares. Basically they are part of the consortium. And then there's Reggie Kukama, who's leading the consortium. Mazi owns 50%, and the other 50% is owned by Reggie Kukama, with an understanding that about 17% will be allocated to women, I think 12 months within the financial closure of the transaction.
70% of his share or of the whole?
Of the total.
But then one assumes that Kapum Patlele, the guy who started all this, is within the Mazi Capital shareholding.
Is within the Mazi structure.
Is that correct? Okay.
That's correct. So the DC valuation range came in between 3.9 and 5.4 billion. 3.9 on the low range being the conservative case, as well as 5.4 on the management case, and then the consortium case came up to about 4.6 billion for 100% of the company. Some of the key valuations considerations took into account that current beef is an established business with 45 years trading history and a very strong client base, very strong brand, leading supplier of beef in the market, strong financial performance and profit history. Over the past 5 financial years, that is being 31 July 2014 to 31 July 2018, the company processed on average 400,000 head of cattle per annum. And EBITDA, which is earnings before interest, tax, dividends and depreciation and amortization, in excess of 500 million rands per annum. So that is essentially during that period. So this is not a new company. It's got a track record, and essentially in doing valuation, you don't look and say that what is management presenting to you. You basically look at the historical performance. And based on this, we are satisfied that, look, we could essentially come to an agreement on a reasonable transaction for both parties.
Clarify this for me, sorry, please. The head of cattle, which they have, you said is 150, I think,
That's correct.
150,000.
Yes.
And how does it happen that they can then kill 400,000 per annum?
Commissioner, so what they do in the cattle feeding industry, you take the cattle in, 150,000 at any given time, you feed them for 4 months. And after 4 months, you basically take them to the abattoir, and then you slaughter, and then you bring new cattle in on a monthly basis. So, so essentially, you take the 150,000 cattle, that is the capacity of the feedlot, multiplied by 3. That's essentially the capacity of the farm. So you rotate your stock 3 times a year.
3 times per annum?
That's correct.
Oh, I see. So it means it's like, what, 450?
450 is the capacity. That's the holding capacity of the farm per annum.
Yes.
But if you look at 2014, they would have slaughtered maybe 389,000. In 2016, because it is good time in the market, they would have slaughtered about 420,000. So when you average over the 5 years, they would have processed or slaughtered 400,000 cattle, head of cattle on average per month.
Okay. So it takes about 4 months to go from birth to abattoir?
No. Commissioner, through you, what happens is that, so you've got the whole value chain, the breeders of cattle, essentially they would breed, and then the cattle will be on milk for about 6 to 8 months. And then after that period, they wean them off milk and they put them on the field to basically feed on pastures. So those are called weaner calves. So current beef essentially is one of the largest buyers of weaner calves in the market. So once a cattle has been weaned, they basically get sold by mostly the breeders and farmers to feedlots for them to then go on that 3-4 months intensive feeding program. So they get fed from 8 months to about 12 months. And then once they are 12 to 14 months old, depending on their growth and projection, they get sent to the feedlot for slaughtering. Current beef buys on average 33,000 weaner calves per month. 21,000 of those on average come from farmers in South Africa from as far as the Eastern Cape, KZN, Mpumalanga, and the balance of about 10 to 12,000 weaners come from Namibia.
Quite interesting.
So
yeah.
Yes.
Yeah. So the lifespan is about 14 months.
That's correct.
Basically.
Yeah,
Okay.
and that's for the A-grade beef, Commissioner, because it depends on how long you keep your cattle. So for a weaner at about 8 months, during the highest prices of weaner calves, which happened after the drought, people would fetch about 8,000 rand for that calf, 220 kilogram calf. That was the going market price. Some people prefer to keep cattle. People say they give them names, they keep them long, and then the value of the cattle doesn't increase the longer you keep it. After 20 months, 30 months, this is where certain markets prefer the beef. They call it C-grade beef, which is essentially harder, but with certain different flavors. That beef is preferred mostly in the Eastern Cape, rural areas, KZN, and most of the rural areas here. But what you eat at Trump Steakhouse is A-grade beef, mostly from producers such as Karan and others in the market.
I'm just wondering who makes the money.
Sorry?
I'm just wondering who makes the money in this business.
It is the farmer and the breeder. Because if you look, Commissioner, at the last few months,
Judge is a farmer, so he does cattle also. So, but I don't know whether I C grade or A grade.
No, that is A. So if you sell your winners in about 6 to 8 months, that's where they are most profitable. The longer you keep them, the more money you lose, Commissioner.
I've got a little bit of experience in that. I was
Thank
at the
you.
stock fair 4 weeks ago. So
Okay, thank you. The key risks associated with the company, that the company manages actively, are beef selling price, which is essentially a market issue, supply-demand. Weeder prices, which is essentially a market issue. Feed prices driven in the main by the maize price. Agriculture is a very cyclical business and very volatile. So during times of drought, you see input costs of agriculture going up. I read the newspapers Business Day today, see some of the 2 leading agricultural companies, I think it's Pioneer Foods and the others, plummeting because of the uncontrollable input price. So this is a very risky market. It's very cyclical and volatile. What differentiates Karan is that the tangible net asset value underpinning its valuation. The calculated tangible net asset value during the due diligence review process was estimated at about 4.9 billion rands, and more than half of the net asset value was made up of short-term assets, being cattle. So if you take 150,000 cattle with an average selling price say, of 10,000 rands, you've got 1.5 billion rands already in cattle, feed, medicine, etc. There's also significant long-term assets being trucks, state-of-the-art feed mills, abattoir, the farms, and everything, all the developments on that particular property. In the final analysis, RMB recommended an indicative valuation range of 4 to 4.5 billion rands for a 100% non-controlling stake in current beef as opposed to the seller's valuation for 6 billion rands for 100% of current beef. We therefore needed to bridge this valuation gap of 1.5 billion rands on the upper range by entering into robust price negotiations with the seller. He eventually agreed to a selling price of 5 billion rands for 90% of the business, payable in 2 tranches, 4.5 upfront, and then a guaranteed deferred payment of 500 within 12 months of financial closure on condition the seller implemented certain operational plans as well as achieve a minimum EBITDA of about 400 during the said 12 months. But the price adjustment was kept at 200 million rands. The 500 was guaranteed payment to the seller, and they wanted this money to be placed in an escrow account for their benefit. The seller agreed, secondly, to retain 10% of the business for a period of 3 years, during which he will work with the new shareholders to transfer skills and expertise. The seller granted the consortium a European-style call option to acquire the 10% from the Ivo Current Family Trust at a strike price of 200 million rands. The sellers agreed to grant this option to the consortium to ensure that it can also create some value over the duration of the transaction. This was with the understanding that a debt-laden structure may lead to a complete collapse in the structure, with the consortium walking away empty-handed after 7 years. When I talk about the debt-laden structure, there has been a lot of experiences where BEE companies are in deals for 7 years, and after that, if the company is not performing, they walk away empty-handed. You'd have seen the papers last week. Tonga Tulet BEE structure was unwound. It went to the banks. Listening to the commission last week when Mr. Rajda spoke about a transaction where the PIC will take back the shares because the structure has not performed and the BEE parties are out. So this was also meant to at least safeguard certain upside for the participation of the BEE parties.
Can you please elaborate a bit more and explain what is meant by an European-style call option?
Basically, Commissioner, you can exercise this only after the expiry of the 3 years. That is the only time you can exercise the call option. You can basically go to the seller and say that I want to buy your shares for 200 million rands. Okay. At the time of the business case for investing in current beef was developed by the consortium alongside the sellers and was premised on the following key medium to long-term initiatives. 1, as a big company, I think there's opportunities to sell more to the public sector. The targets will be the Department of Defense, Correctional Services, Department of Health, etc. By diversifying produce across product lines. Most of these departments consume C-grade beef, and with the pending acquisition of Manjo Ranch, which has now been concluded, the new owners will be in a position to supply different grades of beef as per the demand in the market, particularly in the Eastern Cape and KZN, where C-grade beef is in high demand. Increased sales in the private sector client. As an empowered company, it creates new opportunities in supplying to their private sector clients, mostly in the retail sector. Terms and conditions are better there. Development of black agricultural skills base.
Yesterday we heard that the Department of Corrections do have their own beef, or own cows. So is there some market there?
Commissioners, so we're not only focusing on the Department of Correctional Services. They do self-provision, but some of the feeding contracts, the beef is procured from macro. We know about that. So essentially, there's an opportunity to basically look and see whether it's the Department of Health not agriculture, sorry, correctional services, defense, what are the opportunities to procure from a black company. One thing that is important to note is also that the premium between C-grade beef and A-grade beef has been narrowing. So it's not like the price difference between C-grade and A-grade is no longer as high as it used to be. So the margins are thinner.
Just a quick one, can you explain what is the difference between A grade, B grade, and C grade? What will I taste? I mean, what will it mean? Is that from Woolies? The A grade is from Woolies, and
Commissioner, the A grade is basically under, in most cases, 14 months of age, between 12 and 14 months. The meat is soft, the juicy, and basically when you buy A grade, you go to Woolies and you pay a bit of a premium. Most of the export market that current services and most of the beef producers service, they buy A grade and then premium, the hind quarter, the fillet, all those type of cuts that are seen as very unique and expensive. C grade is a cow that has been left for more than 20 months. It's been grazing. The beef is a bit harder. The fat changes to about yellowish, and the flavor when you fry or things like that, you can feel very strong, good flavor. But I think in terms of the texture, it's a bit harder, different, yes. So,
thank you.
No, it's fine. Yes, thank you. So, we spoke about public sector, we spoke about private sector. Current beef does some supply to Woolies already. There's Pick and Pay, there's Spar, ShopRite, and others that essentially the consortium have been engaging and talking to. Development of black agricultural skill space. There's an agreement that the consortium will second a number of key resources to work alongside the current beef management team with a view of learning from them and contributing their knowledge and for the growth and expansion of the company. The current management team will remain in place in the long term in order to maintain continuity and stability at current beef. The only person that will retire after 3 years is the chairman, Mr. Ivo Karan. Mergers and acquisitions, the first transaction has been concluded, being Manjo Ranch, which provides an opportunity for current beef to self-provide with regards to feed and to achieve better margins by backgrounding winner calves before putting them in the feed lot. Together with the support of African Development Bank, which had an investor conference in November last year in Joburg, current beef team will also pursue acquisitions in Botswana and Namibia to achieve what is called regional integration in relation to the supply of beef in those markets. The two countries, being Namibia and Botswana, have export permits into Europe and the United States, and current beef currently does not have those. And this is in line with what the new shareholders want to see, growth in the markets that current beef has not previously been in. China, UAE, and the rest of the continent, including Southeast Asia. Malaysia is a big market that is being explored by the current beef currently, and the team that comes on board will also help with initiatives to make sure that those markets grow. China there's a fair bit of supply into China, but there's an opportunity to do more with trade wars with the US, and the team is currently talking to them. Current beef currently supplies beef into the UAE, Dubai, and Abu Dhabi, and there's also discussions now for Saudi Arabia to come upstream. What is critical with this international sales is that the Department of Agriculture in South Africa and their counterparts in those countries play a very important part in basically establishing trading protocols and animal disease controls and a range of issues. So if there's weaknesses on our side, for instance, in relation to disease control, etc., You see instances whereby, with the outbreak of foot and mouth recently, there were embargoes in relation to agricultural produce from South Africa into China, UAE, and things like that. That's a very critical role played by government in relation to making sure that market stability is achieved in agriculture. So those are the markets that, that we're looking at. Egypt already receives a lot of beef from current beef, and it's also geared to grow. But the rest of the continent is where African Development Bank is excited to work with current beef to essentially make sure that there's growth and expansion into that particular market. And lastly, there's an emerging farmers development program, which I talked to when I deal with the issues that were approved at the Competition Commission and the Tribunal. But what is essentially aimed at here is to make sure that current beef seeks to ensure that they can procure more winner calves from black farmers. And this program will ensure that procurement from black farmers will increase from the current estimated 3% to about 15% in the short to medium term, that's in the next 3 years. The program is obviously dealt with elsewhere in the submission, but those are some of the initiatives as we develop the business case. So the business case, Commissioner, is not aimed at selling beef to the Department of Correctional Services only. I think there's a broader plan in terms of what the new promoters have in mind.
Just a question, in terms of this growth strategy,
Yeah.
are you gonna need to raise capital, from the PIC or the shareholders, and what's your debt capacity?
So essentially, the debt carrying capacity of the organization is dependent essentially on the EBITDA. So if you look at the EBITDA currently, say 500 million rands 3 times, that's as a rule of thumb. Maximum what you can raise, you are safe when you are around the number of 2 times EBITDA. The African Development Bank is quite interested in providing long-term funding in the form of PREVs for Botswana, and also providing some expansion capital. But that is not done within Current Beef. We said to them that we will put a company called Current Beef International, which company will then focus on the rest of the continent to basically acquire, say, feedlots in Botswana, acquire feedlots in Namibia. But what is important there, you'll see the cattle population in those countries have been decreasing over time. There's a very great need to reinvest in those economies in terms of cattle breeding and things like that, so that they can continue being able to supply cattle into South Africa, but also at the moment, they're not meeting their quotas in relation to the EU, and also essentially being able to supply into the EU market. So African Development Bank, through Current Beef International, will provide that expansion funding.
So you might not need further capital, from the PIC?
No. I don't think it's the intention, Commissioner.
It's the intention.
No. The Current Beef transaction is big enough on its own.
Yeah.
And,
but I'm not saying it's a wrong thing. I'm just saying I just want to find out. Yeah.
No. It's not the intention. It's a big enough transaction. The focus is for the B parties to pay down their debt without taking debt on debt. That's correct. So next section, I deal with how the pre-PAC process in terms of approval process took place. On 11 May 2018, PMC1 gave approval basically, and afterwards the teams engaged the service providers, being CDH, Deloitte, and Genesis Analytics, to provide what they call hold harmless letters for them to be able to rely on the due diligence reports that will be coming out of those service providers. PMC2 gave approval on or about 6 July 2018. And then the investment committee was expected to sit on or about 31 July 2018 for final approval, but this was postponed. The IC meeting eventually took place on 14 August 2018, and it approved the transaction with a condition that the PIC CEO goes back to the seller to negotiate a transaction on the following terms and conditions: that the PIC will own 60% of the SPV, the consortium, B consortium, will own 30%, and then the sellers will retain 10%. Total price kept at 5.2 billion, with a base price of 4.5 billion. 500 million rands earn-out payable or achterscot payable after 12 months upon achievement of certain operational and financial milestones. The previous terms provided for a guaranteed 500 million rands, but the IC wanted this to be an earn-out or achterscot. And then the 200 million rands to be paid by the consortium after expiry of year 3 on condition that the seller achieved certain EBITDA targets as well as operational targets. If BE is not able to raise 200 million rands to exercise its option, PIC can exercise this option. The PIC CEO and the deal team...
Just hold on there, please. Just hold on. So the consortium price was around 4.6 billion, if I can remember.
That's correct, Commissioner.
And then you agreed finally on 5 billion, I think.
For 90%.
For 90%.
Yeah.
Oh, I see. So crossing it up 200%, what's the total value?
So
like if you gross up that
I think if
90%.
If you take the 4.5 billion rands as a base price, and then you essentially say that it's 90%, if you have to cross it up, I think, because remember the 200 million rands is discounted deeply. That 200 million rands should come in at about 500 million rands, but the seller agreed to discount it. So crossing it up won't really give you the right number. Yeah.
5 billion.
5 billion is,
is that correct?
5 billion is for 90% essentially.
Yes, because if you gross up 4.5 billion to 100% is 5 billion, as far as I can see.
Okay, that's correct.
We can double check that.
We can double check that, yeah.
Yes. So the price is 5 billion, which was agreed between you and the seller, no?
For 90%.
For 90%.
That's correct.
So if you gross it up further, is more than 5 billion rands.
It's more than 5 billion rands, yes.
Which gets closer to the 6 billion rands that the funder was looking at.
To 5.5.
To 5.5.
To 555. But then you basically discount the 200 million rands for the remaining 10%.
Yes.
You cap it at 200 million rands, and you get to 5.2.
5.2
That's
billion
correct.
rands. Oh,
Yes.
I see.
Yes.
So it's why it was kept at the 5.2.
That's why it was kept there.
I see.
Another consideration is that when the valuation was done, you basically had the range from RMB saying 4.5, that's the range. So the guys looked at the upper range, which is 4.5. That's for 100% non-controlling stake in the company. And then they basically said that, okay, we'll add a control premium because you're buying 90%. And basically it reconciles back up to that 5.2 billion rands. But as the deal evolved, that other balance became a pure earn-out or achterscot.
Okay, let's proceed. We might come back
Yes.
to this one, but it's fine.
Thank you.
Proceed.
So 28, the PIC CEO and the deal team negotiated the final deal terms with the seller and reached an agreement on terms and conditions proposed by the IC during the middle of August 2018.
Can I just interrupt you there?
Yeah.
Did the CEO, the then CEO of the PIC, did he play an active role with the deal team to clinch the final deal?
There was one meeting that took place in Pretoria where he invited the seller to give him feedback on the outcome of the meeting of the investment committee and said that the 6 billion rands is not really approved. These are the new terms. And then basically the seller went away to say that, look, I'll consult with the team and my family and come back to you. And he came back that, look, I mean, we can do a deal on this basis. I understand that this final deal terms was submitted to the IC for final approval based on the above terms via round-robin resolution on or about 23 August 2018. We received a deal approval letter on dated 23 August 2018 from the PIC on 27 August 2018, which signified final approval of the transaction by the investment committee. What was not clear in the approval was that it did not deal adequately with the funding terms for the consortium, for the B consortium, other than approval of the call option for the acquisition of the seller's 10%, the remaining 10% of the seller. The funding discussions between the PIC and the consortium occurred as follows on 3
Sorry, can
September.
I ask you, were you expecting that the detail of the funding terms to be in that approval? Because this implies that you then had to negotiate it afterwards.
That's correct. Normally the process, Commissioner, is that once the deal starts, there's something called a term sheet. You receive a term sheet which says this is the deal, this is a structure, this is your funding, pricing and things like that, and you negotiate it and sign it with the PIC. But in this case, that was not available. It only was emailed to the consortium on the 3rd of September 2018 after IC approval. On 3 September 2018, we received a funding term sheet from the PIC deal team containing detailed terms and conditions of funding the consortium. Key terms proposed in the term sheet were onerous to the consortium and thus not accepted. This term sheet is attached as Annexure KB2 to the submission. Key challenges with the
Mr. Lebo, we don't have these annexures. I assume they will be made available to us?
They will be made available, Commissioner. No, I don't know. They'll be made available.
Can I just inquire, have they been made available, Mr. Commissioner? Are they with you?
Sorry, can I just come back to this question of the funding terms? So the implication of that is that the committee simply approved the investment, but how it would be funded and the detail of that was left till afterwards for you to negotiate?
The funding terms for the big consortium, basically they approved a global amount and said 5.2 billion rands. PIC will take 60%, the sellers will retain 10%, and then BE will be funded to the extent of 30%.
Sure, but you didn't know the details
No.
and the costing structure or
No,
anything else?
we didn't know those things.
Does that imply that the PIC also had not worked that out? That it was post-approval that this was worked out?
I think they had essentially applied their minds to it, but the key thing is that it's normally formalized in a form of a term sheet. Without that, it's guesswork.
Just another question here. So, in terms of the total payment that this consortium will pay, the PIC has kept it at 5.2 billion rand.
That's correct.
And this is what the PIC, this is what this consortium will pay.
That's correct.
Finally.
That's correct.
Not the 6 billion that the seller has been, hung up on and all that.
No,
Okay.
that's not a 6 billion.
And just in terms of deal structure, just break it down in terms of the equity and the debt portion, and talk a bit about the dividends coming from the company. If you're going to deal with it later, it's fine, but if not, maybe we can look at that.
So essentially, the deal is structured along the following lines, Commissioner. One of the companies is a farming operation, so it's a sole trader. The feedlot is a sole trader. So we basically going to create what is called current beef farming, PTY Ltd, which will buy the assets of the sole trader, being the farms, the cattle, and everything into that particular new company. So in the split of the 5.2 billion rands, PIC on its own takes 60%, say of 5 billion rands, which is around about 3 billion rands. That's essentially PIC's own shareholding on behalf of its clients. Its clients being the UIF, Compensation Fund, and the GPF. So that is what PIC will hold. That's
This is straight shares,
That's
straight,
equity,
the
that's pure
equity, yes,
equity.
straight equity.
And it comes in the company called Pelo Capital Holdings, which is an SPV that has been set up for the acquisition of current beef. And in Pelo Capital Holdings, then you've got Pelo Agricultural Investment, which is the BEE company that is owned by the promoters. I'm talking about the structure that was in the term sheet that was signed. Pelo Agri will own 15% of the SPV funded using debt from the PIC. And then the other 15% will be owned by Workers' Trust as well as Community Trust. So that's a 30% in an SPV
Led by the PIC
funded
also
by the
through
PIC
debt.
that flows into Pelo Capital Holdings. So in a nutshell, that's how the structure is set up. But what is important to say is that Pelo Capital Holdings, because it's an SPV, the push down of the money from Pelo Capital into current beef holdings flows in the form of equity and shareholder loans. There's no senior debt that flows down from the structure. So shareholder loans may be shareholder loans, but naturally, by operation of the law, they are subordinated in favor of the other senior lenders.
All right, okay.
That is
No.
how the structure
Yeah,
was
no,
put
no,
together.
it's fine. I think we'll see it there, you know.
Yes.
In terms of the dividends, or, you know, talk a bit about that.
So I think I also talk about it later. In fact, yes, at the bottom of page 19, if I may continue, and then I'll get to
Yes,
it.
please, yes, please.
So the key challenges with the proposed vanilla funding structure, which are contained in the PIC term sheet, were that the funding for the consortium at that point, if you look at the total amount of 5 billion rands, was about 1.75 billion rands to the BE SPV. Now, the PIC wanted the promoters to provide personal suretyships on 1.75 billion rands. And we said, but these guys don't own that much money for them to be able to provide personal suretyships to that level. The second one was that the funding rate was South African government bond, a 10-year bond, plus about 700 basis points, 7%. Which came to about 16.5%, and the consortium felt that this was exorbitant given the nature of the industry. Agriculture is not like mining, where today you can have super returns because of a commodity boom. It's a very steady industry with growth on average at inflation rates. Now, if the company grows at around inflation rate, and then your debt facility grows at about 16%, you're basically having a funding gap that you create from day one. Huge funding gap. And we said to them that, look, guys, we're going to not be able to fund this, because even the dividends that we calculated, we said dividends that will come from this company on average, say 500 million rands per year, between 300 and 500 million rands a year. BEE essentially will need to take this as an option and hope that the company runs, and then from there they can sell and make some money. We said that, look, I mean, if you lend money to an entity knowing full well from the beginning that they're not going to be able to pay it back, is it not reckless lending? That we've run the model, we've done the calculations, you can see that this instrument will grow from 1.75 billion rands to 3.5 billion rands in 7 years. For the B parties to break even, it means that the value of current beef would have moved from 5.2 billion rands to 12 billion. For them to just break even and walk away with zero. So we said, this is not a sustainable funding model. Let's discuss about a different model. So essentially,
So basically, there is no PE deal there because,
No.
you know, the numbers don't stack up. You know?
no, they don't stack up.
Because of the pricing that the PIC has given you.
Because of the pricing and because of the industry that we are in,
Yes.
we cannot really, with a clear conscience, say that current beef is going to grow at 12% per annum. Beef is a very sensitive industry. Once prices of beef start increasing out of control, people go to eat other substitutes. And so we don't expect in a long-term pricing model of beef that it will essentially be like a commodity like manganese where it can increase 50%, 60%, 100%. So we needed to have what we call a very conservative BEE funding structure that takes into account all of those realities.
Okay, thank you.
The consortium met with the PIC deal team on 12 September 2018 to explore alternative funding structures. The consortium proposed a funding structure including investment holding company structure in line with that is what is normally used in the private equity sector. The structure was agreed in principle with the deal team, subject to the consortium providing a written motivation for the new BE funding structure. We wrote a letter dated 17 September 2018 to the PIC CEO proposing an alternative deal structure based on our discussions with the deal team. This letter is attached here to as Annexure KB3. Basically, where we said that let below Agri contribute 50 million rands, which is essentially 1% of the 5 billion rands required by 2.2% of the company, and essentially put a team together that will go in, manage the asset on behalf of itself and the PIC, and then you look in 7 years and say that after year 7, the value of the shares would have grown, say, from 5.2 billion rands to, if it's 8 billion rands, you calculate the return that the PIC requires, and then the upside created there from you below would basically participate to the tune of 20% of the net profit in that structure. So they thought that it makes a lot of sense. RMB thought that it makes a lot of sense. They were quite involved in helping develop that particular structure, which we thought that it's sustainable, and sustainable on the basis that even after 7 years, or even any time during the period of 7 years, if this team is not performing, the payroll team that said that we'll go in, we'll implement transformation, we'll do emerging farmers development program, we'll grow international markets. If they're not performing, PIC is well within its rights to say, guys, you're not performing, we're canceling the management agreement, we're going to find somebody else who can essentially do a much better job than you. So that is the structure that we felt is sustainable, that we put forward, and it was accepted. So the proposed deal structure was approved with minor amendments, and the deal term sheet was amended, approved by PMC2, understand it was approved, and signed by the consortium and the PIC CEO on or around 10 October 2018, subject to final approval of the IC. This deal term sheet is attached here to SKB4. So it became clear that that step of BE funding was missed at that IC, so it needed to go to the next IC for finalization. A copy. Okay, so I think the shareholding structure we spoke about, but we've also attached that copy of the shareholding structure as Annexure KB5. During the period when we were busy negotiating with the PIC funding terms for BEE, legal teams and advisors were in the process of drafting relevant legal agreements between Current Beef, PIC, and the BEE Consortium. The following agreements between Current Beef Pty Ltd, PIC, Pelo Capital Holdings, that is the acquiring SPV, and Pelo Agricultural Ventures being the BEE Promoters Company, were negotiated, settled, and finally signed on 22 October 2018. One is the sale of shares and claims agreement. Two is the sale of business agreement. And three is the framework and implementation agreement. Those were signed on 22 October 2018. Due to the strategic role...
Just another quick one.
Yes, sir.
Just in terms of the workers' trust, I would assume that these are Current Beef workers.
That's correct.
Did Current Beef participate in facilitating this? I mean, these are like long-serving workers, who have made it successful.
Yeah, so through you, Commissioner, what we've decided is that this is a condition subsequent to the deal happening. So for you to set up a properly well-governed workers' trust, you need to spend a lot of legal money and set up trusts and all of those things. So we said that this workers' trust will be dealt with within 12 months of financial closure, and then it is at the sole discretion of the PIC, because people would ask who's in the workers' trust, who's in the community trust, and all sorts of questions. So we said, PIC, you'll deal with it, and perhaps all you need to find out is who are the workers, the criteria, but drive that process for us, because we didn't want to get involved in the sort of questions and who's that and all of those things. And we felt that it's PIC's competency to help structure that, given that they've done a lot of these things.
But did Current Beef participated in sort of helping the funding of the workers' trust?
No, it doesn't exist as of today. We will do it once financial closure has occurred. But PIC, Current Beef, and the consortium will basically work together, but this will be led by the PIC.
Okay.
Due to the strategic role that Current Beef plays in the market, the deal was announced in the mainstream media on 23 October 2018 under the heading PIC and Pelo buy majority stake in Current Beef for 5.2 billion rands. All newspapers carried that title. Various interviews on the radio took place to give more details of the transaction, and that it was subject to the fulfillment of the remaining conditions precedent. The major one being the approval by the Commission, the Competition Commission and Tribunal, and the other major one that I forgot to mention here that we thought is minor was the funding agreements between Pelo and the PIC. Negotiations continued, and Pelo agreed the PIC and Current Beef Pelo agreed the PIC and Current Beef on the remaining agreements and finalization of the conditions precedent. So we had weekly calls with teams from the PIC, the legal teams, to basically go through the conditions precedent. The original long stop date of the transaction was 31 January, and the PIC needed to make sure that various agreements with Pelo were finalized and presented to the investment committee before that date. Long stop date, Commissioner, is a date when the deal is cancelled and falls apart.
Mr. Commissioner, is this a convenient moment to take the lunch adjournment?
We'll take an hour. Adjourn now until 2 o'clock.
Thank you.